As someone who deals with VA disability claims on a daily basis, I hear all sorts of myths or misconceptions about the VA disability system. Welcome to VA Made Easy. I'm VA accredited attorney and U.S. Army combat veteran Ed Farmer. Today I want to discuss 5 myths about the VA disability system. If you need some more personalized help on your VA disability claim, visit me at vetlawoffice.com. For now, let's get into it. VA myth number 5. If the VA treats me for a condition, it must be service related. I hear this myth several times a day. I was denied sleep apnea, but they prescribed me a CPAP machine. I was denied hearing loss, but the VA prescribed me hearing aids. I get PTSD treatment and they deny my PTSD claim. Listen, just because the VA treats you for a condition, that is not an admission that that condition is related to service. Depending on what your status or priority is with the Veterans Health Administration, you may or may not be eligible to get treated for both service-connected and non-service-connected disabilities. So just because the VA chooses to give you a CPAP machine or hearing aids or treat that condition in some way, that doesn't mean it's related to service. You have 3 things you need to do to prove service connection with the VA. 1, you need a current disability. So if you get treated at the VA facility for that condition, you've already met that requirement. 2, you need to show that something happened in service. And 3, you need a medical link or nexus between that current disability and the event that happened in service. So getting treated for that disability is not enough to obtain service-connected disability. You must prove all 3 elements. VA myth number 4. I was exposed to toxins in service, so I need to be compensated for that. Exposure in itself is not enough to get VA disability compensation. Yes, it's a scary thing to have been exposed to some sort of chemical or toxin or whatever it may be in the military, but that's not enough to get disability compensation. As I just mentioned, you still need to show, 1, that you have some sort of disability from your exposure. If you don't have a disability that you believe is from your exposure to toxins, then you don't have a claim. If you do have a disability that you believe is related to toxic exposure, then you still, in many instances, need medical evidence showing that that disability is as likely as not related to the toxic exposure. VA myth number 3. If I get a medical nexus opinion, I'm sure to win my claim. Not necessarily. Not all medical nexus opinions are built the same. There's a lot of companies out there online purporting to give you medical nexus opinions. And I'm here to tell you, they reuse opinions, they recycle opinions, they just kind of plug and play your name where it needs to be. A lot of them don't even have good rationales, and that's important for a VA medical nexus opinion. If the doctor or medical provider can't explain why your condition is related to service, that opinion holds no weight. Work with a VA accredited attorney that understands what it takes in that medical nexus opinion to win your case. And again, the medical nexus opinion is just one piece of the puzzle. You still need the current disability and you still need to prove that something happened in service. VA myth number 2. If I just keep appealing, eventually I'll win my case. This seems to be the mantra of a lot of veteran service organizations. Just keep appealing, eventually somebody will grant it. Well, maybe you get lucky and your case gets overturned on appeal, but the smarter thing to do is to find out why you were denied your case. Find out why you were denied. Get new evidence that could help win your case, or find a legal error that they potentially committed. You're going to have better success if you know why you're denied and you help build the evidence or make arguments as to why you shouldn't have been denied. And VA myth number 1. I can't afford a VA accredited attorney to help me win my case. Incorrect. Most VA disability attorneys charge a contingency fee. So what this means is they don't get a fee unless they're able to get you paid as well. So most VA attorneys work off a percentage of the back payment. So if they are able to obtain you some back payment, they ask for a percentage of it. Unlike the claim sharks who ask for 5 to 10 times the amount of your back pay, a VA accredited attorney would never do that. We are regulated by the federal government. We're limited in what we could charge you. So you can afford a VA disability attorney, and we do a better job than most of the claim sharks out there. Watch my other videos about why you shouldn't hire an unaccredited representative. I'll put the links in the description below. And that does it, guys. Those are 5 myths about VA disability claims. Keep liking, keep sharing, keep subscribing. If you need additional help, visit me at vetlawoffice.com. And as always, you have the power to change your VA claim.